In People versus Michael Haley, this is file number 256876. The record should reflect Mr. Haley's present in the courtroom today due to Mr. mobility limitations. I'm just going to have you stay right there at the chair, Mr. Haley, as opposed to the podium. Anything on behalf of the people for allocation?
Briefly, Judge.
Welcome to Loreality. Today we witness the intense sentencing of 71-year-old Michael Haley, accused of murdering the man who put a roof over his head. Haley claims it was all to protect his son, but the prosecution says it was a cold-blooded betrayal.
I was present during the defendant's trial, where even the defendant's own son testified that he couldn't understand why his father, the defendant, then shot the victim, who his son described as a good man, effectively allowed the defendant and his son to live in his home. Even when the son wasn't working for a time, 2 to 3 months, when he wasn't even charged for that. This generosity was returned at the defendant by effectively, unfortunately, killing him in cold blood. There's no sentence this court can impose that will effectively, truly give the victim's family justice. However, as our state and legislatures deem this offense which the defendant committed select offense, the court is limited in what it can do in regards to sentencing. Thank you.
Thank you. Mr. Brown, anything on behalf of Mr. Haley?
Mr. Haley is in very poor health. He is 71 years old. I understand the jury verdict. The court, I am certain by reading through the PSI, Mr. Haley still does not agree with that verdict. He is going to appeal, which is his absolute right to do. Any sentence, quite frankly, at his age, especially within the guidelines, Your Honor, is more than likely going to be a death sentence.
Thank you. Mr. Haley, is there anything you wanted to say today?
Yes, I have a statement I'd like read into the record, if I may.
Certainly.
Unbeknownst to you, me, or Mr. Brown, approximately 7 to 3 days before my trial, and I'm going to say this probably came out of Mr. Rolla's office because it only could have. Through Facebook, TikTok, and the local media news, put his thumbs on the scale of justice by promoting and releasing several falsehoods. It's alleged that the trial took so long to be concluded because I tried to fire my attorney at the last minute to postpone the trial, thereby avoiding justice system, and that I was laughing at the justice system. I'd like to point out that I never once asked for an adjournment. I was trying to replace Mr. Brown as my attorney starting in July. And I even voluntarily waived my rights to an arraignment to speed things up, thumbing my nose at the Otsego County court system and thought I was smarter than they are. That was reported on all 3 medias. It also stated that I only killed Russell DeLong in a failed attempt to stay in his residence on the property, which unfortunately that's laughable. Because number one, the property wasn't his, it wasn't even in his name. And number 2, upon his death, I would have had absolutely no rights except rights as a long-term renter, and I would have had to have been evicted. The only witness that the prosecution had was my son and one friend of Russ's. The summons to my son was sent to a residence that he hadn't lived at since high school. If he hadn't been looking for that summons to appear, he would have not even shown up. I really question how the summons got sent to a Grand Ledge, Michigan address that he hadn't lived at in well over 20 years. That's very strange. Wish I could have a better word to put this, but I would term it shenanigans in losing the thumb drive during the trial.
As Haley addresses the court, the hearing takes a wild turn. Instead of showing remorse, he accuses the prosecutor of rigging the trial through secret TikTok and Facebook campaigns, claiming a massive social media conspiracy ruined his chances of freedom.
And trying to blame it on the court reporter of statements made on the initial interview by my son to the police, I feel that influenced the jury. I actually feel that Mr. Rallis should be found guilty of judicial misprudence with malice. Now, I had been warned in advance by 3 different attorneys that worked with Mr. Rallis in the prosecutor's office that this was a common practice with Mr. Rallis. But I never thought that anybody would try to throw their thumb on the scale of justice in a matter like this, when I never once said that I didn't shoot Mr. DeLong. I gave a voluntary statement to the police of the whole facts of the matter the night of the incident. I wasn't trying to duck responsibility. I wasn't trying to do anything except point out that I shot Mr. DeLong in fear for my life, and I never contemplated doing anything of the nature until he said that once I was dead, he was going to shoot my son in his head in his sleep. I fail to see how the jury pool could not have been contaminated, at least on a few of the jurors, with this media blitz just before the trial. The facts are, Mr. DeLong kept a handgun in the arm of his chair. As a fact of course, there were guns stashed all over the house. Several guns. I pointed out to the police at the time of the incident that there were illegal full automatic weapon firearms in the house. They never did anything about it. Now, I was never threatened with any of those illegal firearms. It was always with a pistol. But the cops never looked into that, ever. 3 days after the incident, the ex-brother-in-law of the deceased was allowed to come over and remove those weapons from the house. Another thing I disagree with was I repeatedly asked Mr. Brown to do an investigation and go take pictures of the entrance and egress on the house. Had I tried to leave the house before I shot him, the only way to get out of the house was to go past an armed individual that was in between me and the only exit that I was able to use to my legs of the house. I would have had to go past a man that I honestly believed was armed. And he had previously showed me the weapon and put it back in the arm of the chair. I don't know where it went. I don't know if he had time when I went to my bedroom and back to pitch it, move it, or I have no idea. I tried to get Mr. Brown to do an investigation, even to take pictures of the stairway. Unfortunately, there is 16 steps going from the ground up to an elevated deck. I call it the stairs from hell. It's a tough walk. My right to a speedy trial, I feel, was violated, and not by any doing by me. And it was reported in the news, TikTok, and Facebook that I was the one that slowed the trial down, and I was laughing at the Otsego County court system. I think my right to a fair trial was violated by the last minute rush in the news, TikTok, and Facebook. I fail to see how that could not have influenced at least one or more of the jurors. At my age and my condition, my life was not that important to me. But when Mr. Long said after he killed me, he was going to kill my son, that made my decision for me. And I make no apologies for it. This victim statement by the brother that I only now got aware of, I'd like to point out a couple things to your honor. Jeffrey DeLong and Russ DeLong had not spoken to each other in almost 20 years. They hated each other. So Russell's quote unquote home, which was never kept in his name to my knowledge, and I was paying the delinquent taxes on it. Not only that, I was paying rent for years. and my son was paying rent too. Mr. Rowell alleged that Mr. DeLong, the deceased, Mr. DeLong, had even let my son off on paying rent while he was suffering from cellulitis and couldn't work.
So, Mr. Haley, I'm perfectly willing to hear what you have to say about your case as part of
Being
sentencing,
too-
but whether you agree with the victim's, his brother's statement or not, I mean, what does that have to do with anything?
Okay, all I wanted to say was, Jeffrey DeLong ended up, due to these circumstances, he ended up the sole beneficiary of the father's estate.
Okay.
The judge refuses to buy into his narrative. She quickly cuts through his rambling, pointing out that trashing the victim's character does not legally justify pulling the trigger. If you want to see more shocking courtroom moments just like this, make sure to subscribe to the Law Reality channel.
And I'm going to quit talking about that.
I just don't understand what that has to do with the punishment that you should receive in this case.
Okay,
I mean,
to
if you
cut to the chase,
if you can tell me, yeah.
drug it on so long.
Well, it's not that you're dragging it on, it's that
It has no import.
the victim's brother is entitled to feel however he feels, regardless of how good or bad their relationship. When you have somebody who's a family member who's killed, even if they're estranged and you don't like them, it can affect you. And so it's not that you're dragging things on, it's just what you're saying.
I can understand, Your Honor.
Yeah.
I will just leave it at that, Your Honor, and apologize for misusing it.
Well, there's nothing to be sorry for. I suspect your attorney's giving you some good advice, which is,
To shut up.
well,
Yes, sir. Yes.
well, none of what you're doing is, to me, it sounds like you're saying, well, these are more reasons why it was okay for me to shoot and kill Mr. DeLong, because he didn't manage his affairs correctly and his brother really didn't like him and he was just a bad guy who didn't pay his taxes, and therefore I killed him. But you know, it's not that big of a loss to anybody. I mean, that's what it sounds like to me. So I think your attorney telling you to stop saying those things is probably
Sorry to
good
interrupt, Your
advice.
Honor.
I was part of all the pretrial proceedings, so I'm aware of everything that's happened from start to finish, at least once the case was found over. And I pay very close attention, especially in trials where there's potential for publicity, because I want to make sure that the defendant and the prosecution get a fair jury and get jurors who don't come to the case with preconceived opinions about how it should be decided. I didn't see any kind of media blitz, as you indicated. I think there was one article on the local news that the trial was starting, but I didn't see any of the things that you're discussing. And I'm on Facebook and TikTok and those social media websites, so I don't know how accurate what you're saying is. I didn't see any of that. More importantly than that, though, is the first question that I asked every single prospective juror was whether they had heard anything about this case prior to the trial. And every single one of them said that they hadn't. So to the extent that there was any media coverage, not only did I not see it, but none of the jurors said that they saw it. So even if it happened, if none of them saw it, it didn't affect your trial in any way, because there's no evidence, or was no evidence presented at trial, none that I've ever seen, that Mr. DeLong presented a threat to you at the time that you shot him. He didn't have a gun. He didn't show a gun to you. He didn't point a gun at you. He couldn't have, because no gun was in his chair. So whether he's had possession of a pistol in that chair before or not, and whether you knew about it or not, the fact is, under the law, regardless of whether you think it's good or bad or agree with the law says that that person has to be presenting an imminent danger to you at the time. And him sitting in his chair and threatening to kill you is not enough for you to go get a gun and then shoot him at point blank range and try to justify it by self-defense. I mean, it's just, there's no evidence that would support a self-defense theory in this case. So the fact that Mr. Brown didn't go and take those pictures and didn't explain to the jury that you couldn't have gotten out of the house, none of that even matters, because based on the evidence that I saw at trial, none of it indicated that you were at a point then that your only options were to kill Mr. I'm not going to argue with you about it. I heard everything you had to say. I'm just telling you. The issue with regard to the summons to your son, I don't know what that has to do with anything to do with your guilt or innocence or a self-defense theory. The thumb drive, I mean, if anything, I think that would have hurt Mr. Rolla's case because it made him look bad in front of the jury, not you. So I don't know how that could have unfairly influenced the jury against you. I don't think you actually felt physically threatened, and you even alluded to it here today. You indicated that your life wasn't that important and you weren't that worried about it. You were more worried about your son. And certainly there was not an adequate basis here for you to use deadly force in defense of your son under the circumstances as they were at the time that you fired the weapon. So I think ultimately you decided that you were done listening to Mr. DeLong, you were tired of his threats, and you were going to end that, and that's exactly what you did. Clearly a circumstance where you decided to take the law into your own hands. You decided to use deadly force when it wasn't justified, and there's really no excuse for you shooting Mr. DeLong at the time and in the way that you did. And so I do think that a lengthy prison sentence is justified by your actions in this case, regardless of your age or your current condition.
Haley's desperate attempts to claim self-defense completely fall apart. Finding no evidence of imminent threat, the judge delivers a crushing blow, sending the elderly man to prison for 25 to 50 years.
The law demands that the court mete out the appropriate punishment. And in this case, the court is going to sentence you to 25 years to 50 years in the Michigan Department of Corrections. You do have credit for 265 days served. The court will order that you pay a crime victim's assessment of $130, court costs of $325, attorney fees of $350, and a $68 state cost. You do have the ability to seek an appeal of this sentence, and so you'll be able to raise all the things that you've raised here with me today in front of the Court of Appeals. And if I'm wrong about any of that, then I'm wrong and we'll be back. And if not, the sentence will stand, but you do have to file that appeal. And Mr. Brown, have you provided the appellate rights to?
I have, Your Honor, for the record, I did tender the acknowledgement.
Mr. Rolla, anything further on this file today?
Until there's a trial, and until after there's a trial, there's a decision. Our office only releases information that's already on the court record. In other words, information about the charging, the decisions, what potential penalties might be. But as far as any other information, we don't. And in regards to TikTok, I don't use it. I don't even allow it in my home because, again, I don't like the way that service works. And in regards to Facebook, if he's got postings that he's got something to show that someone from my office posted things on Facebook prior to the trial, I would like to see it because then I'll take appropriate action. I do know it wasn't me, so the allegations that he made, I felt compelled to address on the record. Thank you.
All right, thank you. That's all for this hearing today. Mr. Haley, you are remanded to the state.